Good morning, all. Suburban Sentinel here, and today I'd like to weigh in on the Supreme Court Hobby Lobby case. As most of you know, this case dealt with a closely held private corporation's right to opt out of certain federal law regarding contraception. Now, I submit to you that the Hobby Lobby case is not really about women's rights or parental rights or personal responsibility and personal freedoms or Obamacare or even about religion. In my humble opinion, this was the Supreme Court's effort, and successful effort by the way, to expand the corporatist state. So let's take a little closer look at the Hobby Lobby case and the incidents surrounding it. First of all, what is a corporation? Well, in essence, it's an entity created virtually out of thin air, but whose legal existence is recognized by the sovereign or the government of the appropriate jurisdiction. Now, there are a couple of characteristics of corporations that are almost universal. First, there can be a variety of members or people involved directly with the corporation. And two, those people in general are protected from liability. And the rule is basically that a member or investor cannot lose more than they have put in to the company. So those are the two basic characteristics. Now, why do we have corporations? Well, some projects are just too big, too expensive, and too risky for any one individual. By way of example, in the 17th century, there was a lot of money to be made extracting the resources from the New World, what would become North America. So the problem the Europeans had is that it is very expensive and risky to establish commerce that far away. Sending ships across the Atlantic was in and of itself a risky proposition. Many of those ships never made it. In addition, setting up colonies with the express purpose of establishing commerce had its own set of hazards. So no one person had sufficient wealth or was willing to risk all of his or her wealth on such a risky proposition. So this was left to the corporations of the day. At the time of the American Revolution, certain English corporations had tremendous wealth, power, and influence. And the dissatisfaction that spawned the revolution in the colonies often had as much to do with the colonist relationship between or among the colonists and the corporations as the colonists and the crown. So unsurprisingly, early Americans were very, very suspicious of corporations. The new Americans were afraid that corporations would grow and wield too much power. Therefore, early corporate law in America severely limited corporations in what they could and could not do. So, for example, early American companies were created for a specific purpose, such as building a bridge or a canal, and they could go no further than that stated purpose. In addition, the sovereign entity could revoke the charter of a corporation almost at will. Plus, corporations were not entitled, in fact, they were specifically prohibited from trying to influence the outcome of elections or in any way participating in politics. In late 19th century America, the law vis-a-vis corporations began to change. Many of the restrictions on corporations were lifted. And fast forward to the early 21st century, and the corporate landscape is almost unrecognizable. Whether by statute or Supreme Court edict, corporations have many of the same rights as individuals. I believe that our founding fathers were very wise to be extremely wary of corporate expansionism. Just look around at what's been going on in the last few years. For all intents and purposes, corporate entities have hijacked the democratic process and now have great influence on the outcome of elections for public office. In addition, big public companies have successfully initiated a huge transfer of wealth from a thriving middle class to a very few individuals and corporations. Look at the bank bailouts. Essentially, we have privatized profits where questionable or speculative business practices and any profits therefrom go to these few people. But when things go south with these strategies, the public bails out the companies, and they are in effect no longer responsible for poor business practices. I do not believe that the federal government has the authority to dictate to a private employer what benefits that employer may or may not offer its employees. That said, I also believe that resolving the issue by imparting religious freedoms to a fictitious entity is wildly inappropriate and wholly counterintuitive. All this does is open the door for expansion of the corporatist state. So that's all I have to say about the Hobby Lobby case. Thanks for watching. This is the Suburban Sentinel. Please thumbs up and subscribe if you like what you see. Questions and enlightening comments are always welcome. Be safe and happy 4th of July, everyone.